Hello and welcome. Today we're diving into something that's, well, it's both complicated and incredibly personal. Industrial disease claims here in Scotland. For anyone who's been affected, this is so much more than just a legal process, right? It's a whole new reality. So let's walk through what you really need to know.
This just says it all, doesn't it? 1 minute, everything's fine. And then, boom, you get news from a doctor that turns your world upside down. And the cause? It could be a job you had decades ago. It's a huge shock, and it leaves you with so many questions.
And that really is the big question, isn't it? When you're feeling completely overwhelmed, where on earth do you begin? Well, that's what this explainer is all about, giving you a solid starting point, a clear path to follow when everything feels uncertain.
All right, first things first. Let's make sure we're all on the same page. What does the law actually mean when we talk about an industrial disease?
So here's the key thing to get your head around. We are not talking about a one-off accident, like a slip or a fall at work. No, we're talking about illnesses that creep up on you, often over many, many years, all because of the kind of work you did or the materials you were around. It's a slow burn, not a sudden event.
And you can see here, this covers a whole range of things. Because of Scotland's amazing but heavy industrial history, think shipyards, factories, we see a lot of claims for things like asbestos-related diseases, hearing loss from constant loud noise, or vibration white finger from handling power tools day in and day out. Maybe some of these sound familiar to you.
Okay, let's switch gears and get into the legal side of things. See, having a diagnosis is step one, but to make a claim, you have to prove a very specific legal idea, and that idea is negligence.
This is basically the three-point test that sits at the heart of every single one of these claims. You can think of it like a chain. First, your employer had a job to keep you safe. Second, they failed to do that job properly. And third, your illness is the result of that failure. It's that simple in theory.
But of course, in reality, it's rarely that straightforward. And these are the big hurdles. I mean, how do you prove something happened 40 years ago? What do you do if you worked for 5 different companies? Or if the company doesn't even exist anymore? This is exactly why you need a specialist solicitor. They're like detectives, experts at navigating this tricky historical maze. Now, we have to take a moment to talk specifically about asbestos because it plays such a huge and unique role in Scottish law. Our past in shipbuilding, in construction, it meant that a massive number of people were exposed, and sadly, we are still seeing the devastating effects of that today.
And here is a critical, and I mean critical, legal difference between Scotland and the rest of the UK. Thanks to a law passed in 2009, if you are diagnosed with something called pleural plaques, which is scarring on the lungs from asbestos, that itself is considered a personal injury you can claim for. That is not the case in England. It's a vital distinction that makes a real difference for people here.
Okay, I need you to listen closely to this next part, because it might just be the most important piece of the whole puzzle. There are very strict time limits involved, and you absolutely need to know how they work. 3 years. That's the number to burn into your memory. 3 years. But the big question is, 3 years from when?
And here is the bit that I hope brings some relief. The clock did not start ticking way back when you were working with those materials in the 70s or 80s. No. It starts from what the law calls your date of knowledge. That's the moment you found out, or really could have been expected to find out, that you had this illness and that it was linked to your work. This timeline really helps make it clear. Look, you could have been exposed decades ago, while the illness developed silently. But that 3-year countdown only begins when a doctor gives you that diagnosis and connects the dots back to your job. For most people, that date of knowledge is actually very recent.
So, with all of that under our belts, what do you actually do right now? Let's get out of the theory and into a simple, practical game plan.
Here you go, your first 4 moves. Honestly, number 1 is the most important. Talk to a specialist solicitor. Don't put it off. While you're doing that, start to jot down everything you can remember about your work history. Every little detail, names, dates, locations, it all helps to build the picture.
And here's another really important tip. Completely separate from any legal claim, you might also be able to get something called Industrial Injuries Disability Benefit. It's a state benefit, it's not based on your income, and it doesn't affect your claim. So make sure you ask about that.
I want you to really let this sink in. Please do not fall into the trap of thinking, oh, it was too long ago, or that company is long gone. Those are the 2 biggest reasons people miss out. Specialist solicitors have ways of tracking down old companies and their insurers. It's what they do.
And that brings us to our final question. Getting a diagnosis connected to a job you did years ago is without a doubt devastating. But understanding your rights and taking that first brave step to get some advice, that could be the very thing that unlocks the support and the justice you and your family need for the future.